This panel is going to be centered on distressed hospitals, so it's going to run. So if you're in a situation where you're at rope's end and maybe are wanting to turn your operations around, you're in a position to do that, maybe we need to pursue some other form of relief, like bankruptcy, all the way through maybe we need to pursue some other down and closure, which has been discussed today. So I'll let Mr. Banks and Mr. Goodspeed and Mr. Olson and Mr. Williamson introduce themselves.
Good afternoon. I'm Wright Banks from the Georgia Attorney General's office. I'm a Deputy Attorney General in our Commercial Transactions and Litigation Division, and one of the responsibilities that we have in our division relates to the Georgia Hospital Acquisitions Act. So not only do we conduct review processes and hearings under that act, but we engage in a fairly regular dialogue with hospital attorneys, hospital operators, hospital authority officials, county government officials, and state officials regarding various hospitals in the state and various transactions that they might consider that might fall short of having to be reviewed and subject to a public hearing under our act. So that's how I fit in here.
I'm Scott Goodspeed. I'm with Stroudwater Associates, and we're a strategic advisory firm, and we work with hospitals all across the United States. We have a real passion for working with small community hospitals, and I'm going to give you a little bit of a different framework because we like to work with whether it's critical access hospitals or small PPS hospitals before they get to the point where they're at a bankruptcy petition. So for example, we're finishing up a hospital closure study, and we know that there are certain characteristics based on looking at about 15 years of data in cost reports and all the publicly available quality metrics. There are probably some pretty good predictors for boards of trustees and community hospitals in terms of indicators where they may be trending. And this is an interesting time for me because I came in from the state of Washington Monday through Wednesday. I was with a critical access hospital that the board chair and the CEO called, and they may have looked a little bit stressed in terms of their metrics, but they're doing okay today. And then Sunday I'm flying to a hospital in the Midwest that looks a little more distressed, so they're looking at strategic options. But so I'm going to talk a little bit about the role of governance and board of trustees and their responsibility as it relates to understanding their situation and perhaps making decisions a little bit earlier before they get to the point of bankruptcy.
My name is Kirk Olson. I'm with ER Hospitals. We manage 4 rural hospitals here in Georgia. Emmanuel Medical Center in Swainsboro, Candler Community Hospital in Metter, Dormany Medical Center in Fitzgerald, and Irwin County Hospital in Osceola. We're headquartered in Salt Lake City, and I have no idea how we got into Georgia other than we are here.
Welcome to Georgia.
Thank you.
And I guess nobody told everybody about the free beer for those that stayed for the last session, but y'all are lucky. But anyway, my name's Rob Williamson. I'm with the law firm Scroggins and Williamson out of Atlanta. We're kind of a small, I hate the word boutique, but I guess we're kind of a boutique Chapter 11 firm. And we primarily represent distressed companies, both in and out of bankruptcy, that need to reorganize or restructure in some fashion. In recent years, we've represented, well, I've been doing it for over 30 years, and we've represented all types of companies in all types of industries, but it seems like in recent years, I've become more of a hospital and healthcare / bankruptcy lawyer. A number of our clients have been, skilled nursing facilities, assisted living facilities, that type of thing. And then in recent years, we represented Hudson Medical Center, which is a hospital up in Fort Oglethorpe, Georgia, and Southern Regional Medical Center, which is another acute care medical center down south of Atlanta, in Chapter 11 to effectuate basically sales of the hospitals there. So for better or worse, I've probably learned a little more about healthcare law than I ever thought I would due to that. And I'm here to talk a little bit about the interplay between the federal bankruptcy laws and other types of insolvency laws and regulations, and the interplay with other statutes, healthcare statutes, Medicare, the Hospital Acquisitions Act, and things like that come into play when you get to a distressed hospital situation.
So I think we reference it's sort of a spectrum, right? A lot of hospitals are on the brink. A lot of hospitals are vulnerable, but you can tread water for a while because you want to believe that, and it often does, that the tide can turn and you can make it. So we're going to go start with the point where maybe you're not fully at rope's end yet, and you can turn things around, and we'll talk with Scott and Kirk some about that, and then. Unlike the previous panel, we're just going to end on the lowest point possible. Just close out the whole day with bankruptcy and shutdown. And but these guys are going to make it really fun and interesting for you still. So Kirk and Scott, I'll let you guys take the lead on this. What are some strategies you would recommend if a community is considering, they may have board pressure, they're considering, well, maybe we should just shut the thing down. What are some strategies you would recommend for turnaround in that really, we're talking about situations of real distress before you would pursue bankruptcy or some kind of other workout?
So I have a couple of thoughts. There's a pretty good data set, whether it's financial indicators or quality metrics or share metrics that an organization can look at over a 3-year period of time. So I recommend for a board of trustees and a executive team that you put together kind of a good data set. You understand current reality, because I get to the point where sometimes I get a call from a hospital CEO or a board chair where you look at the data and it's just too late. So my first experience was with a critical access hospital in Pennsylvania, where a colleague and I got a call, and we basically said, not only are you trending to bankruptcy, but it will happen the first week in April, and we were there in January. So you never want to get to that point. I'm seeing a number of boards of trustees that I work with in small community hospitals that will put together what I call board triggers. So they'll look at 7, 8, or 9 indicators, and of course, oftentimes they're financial, they're quality metrics, they're physician recruitment metrics, share metrics, and over a period of time, the organizations can get an indication of whether they need to begin to think about strategic options or affiliation, and they're not caught up short. So, for example, this hospital that I just mentioned in Washington State, we got a call about a year ago from the chairman of the board and the CEO, and there were some indicators that they were stressed, and the board was concerned. They put these triggers in place after a year working with them financially and on the physician recruitment side and working with their quality metrics, actually doing pretty well in the face of a lot of competition. There's another hospital I'll be at in the Midwest on Monday where there's a lot more stress, 2 years of financial erosion of the balance sheet, some physician recruitment issues. So they're beginning to look, not beginning, they're actually looking at a range of strategic options. And my only point is you have a much broader range of options. If your balance sheet is stronger, you may take the organization through some type of accelerated operations improvement. And I'm not talking about a process that lasts, 18 months, but typically maybe 6 to 9 months to get the organization to a very different place, then to begin to look at strategic options. So we haven't spent a lot of time talking about boards of trustees and governance. And 10 years ago, I wrote a book for the American Hospital Association on board best practices, and spend maybe 25% of my time with boards of trustees. And I would suggest that for next year, you may want to consider bringing a number of board members into this kind of forum, because I think they need it just as much as the rest of us. And then the other thing that I'm thinking about is, as we complete our hospital closure study, there are predictors, there are indicators, and wouldn't it be interesting, instead of any more than 6 hospitals in the state of Georgia closing, because that's what you're up to since 2010, we could bring that study here, maybe share a list of predictors, maybe get a CEO board panel to kind of spend some time mining that, and they can develop a statewide dashboard for all of those small community hospitals to see who's at risk. And frankly, with everything I heard today and the talent in this room, you've got so many positive intervention strategies, they don't have to get to the point where they have to go through a bankruptcy.
I want to share with you what it's like to be a rural hospital administrator. It is a lonely, lonely place to be, particularly if you're not affiliated with another organization. About 1 year after my graduate degree was completed, I ended up as a hospital administrator in a small town in Montana, Townsend, Montana, population 3,000 people. We were financially strapped. I was there all by myself. I didn't know anything about running a hospital. It was my very first hospital job. My plant operations person went on vacation and the sewer backed up. We didn't have enough money to hire anybody to go in and repair the sewer, and so we hired a backhoe. They dug a hole, and as I was standing in the sewer line trying to find out what was wrong, I thought, I do not remember this in graduate school studies. It's very difficult to be a hospital administrator in a situation like rural hospitals are faced with today. Our approach is to consolidate rural hospitals into a shared services program so that they have support. They have individuals that they can call. We have best practices that we spread between our hospitals. Those are things that need to happen in order for rural hospitals to be successful. I agree that oftentimes they wait way too long. Most of the hospitals that we've taken over in Georgia are a few weeks away from not being able to make payroll. And so we have to do some very drastic things when we get there. Our first analysis, of course, is financial. We go in, we take a look at that. We talk to everybody that we can. We put what we call a financial bridge together. That's presented to the board. If the board decides to choose us as their management company, then we start to implement that bridge, which we hope will take them from where they're at to financial success. Some tough things happen. When you're a hospital administrator, you've been in the community for a few months, you go to church with folks that work for you. The mayor's daughter works for you. The county commissioner's wife works with you. And it becomes very, very hard to make the tough decisions that need to be made in order to turn your hospital around. And so we put it off. It's just human nature. Our approach to that is to come in rapidly because we get attached. And so within the first few weeks after we take over a contract, we make the tough decisions. And I don't know that there's a hospital that we have taken over in any location that we haven't had to make those tough decisions and let a number of people go and restructure the organization. So part of what I think we have to learn to do is maybe cry uncle sooner and get help sooner. I agree with the folks that have spoken. There are many, many resources here in Georgia in order to do that. And with the focus that's being put on rural health care, we need to take advantage of all those resources and do a better job to transition before we're 2 or 3 days away from not making payroll.
Thanks. And Wright, you're a pretty good bridge here because your office reviews. So there's the Hospital Acquisition Act, which mandates a review from the Attorney General's office, which Wright is going to speak to. But sometimes people aren't sure if they run up against it, if they're covered by the Hospital Acquisition Act. So Wright's office reviews everything from management agreements in some cases all the way through sales and dispositions, that even when they're covered by bankruptcy. So, Wright, if you could speak to the role your office plays in that process and the service you seek to provide, and also just the interplay of and we'll hear some of this from Rob as well, the interplay of the federal bankruptcy law, if the hospital is eligible for it, and we'll talk about that some later, the bankruptcy law and the state law on the topic.
Sure, and I would echo one thing that's already been said, or maybe two, that we see transactions come to us. They don't know what the transactions. People don't really know when to start reaching out. I had a meeting yesterday where there's a set transaction. It's going to come to us. It's almost ready to go. They've almost signed the agreements. It's going to involve a bankruptcy filing. But we see transactions coming to us from in all stages. And going back to what was said, very often people are coming to us too late in the game. They have let their local hospital sort of linger. And I work in government. I don't know who does here, and I won't offend anybody by saying this, but government bureaucracy day to day and local hospitals very often, if the mayor's daughter works there and the county commissioner's wife works there, the person running that hospital day to day, it is not their money. And government will postpone a hard decision as long as possible. That is just the nature of government operations. So we see people coming to us, they've waited till they're in some real distress. They may not appreciate that they're in real distress, but they're in real distress, and we also see people coming to us, going back to board dynamics, where they don't necessarily have their own house in order. And by house in order, I don't mean their finances in order at the local hospital. I mean, you've got a local hospital authority board, you've got a local nonprofit corporation probably operating the hospital under an agreement with the authority, and you've got a local government setting. You may have a county that has backed some of the debt, and that house will not be in order. You will get the CEO will come to see you, and he might have the board chair of the corporation, and they come and they say, we're in real trouble, need to do a deal. We're going to be coming to you with something. And you kind of think, well, why did you come to see us? Because you don't really have anything to tell us. They will leave and go back to wherever they came from. The next day, a phone call will come to our office from the state representative for that area. And he'll say, what's going on at the hospital? And of course, if they call and ask us, we tell them. We had a meeting. This is what's going on. And I don't have enough fingers and toes to tell you the number of times that state representative then says, well, I don't know anything about any of this. You're headed for real trouble. I told somebody yesterday, I said, all your transaction elements, I'm not telling you how to do your job. I know you got the business deal to do, but you've got to cover, you can never lose sight of the fact that this is a governmental or quasi-governmental hospital. You can never lose sight of that fact. And you've got to cover the various boards, the various political officials. So what do we do like every day related to hospital acquisitions? It's one of two things. Either they come to us with a management agreement of some sort that they are worried goes too far in terms of giving control to the manager, and they want a comfort letter from us that says this will not put you in the position of having done an acquisition without our office having reviewed it. Some of those management agreements, to be candid with you, we look at them and we say, and the party that's going to be managed really needs to do a deal where they either sell that hospital or they do a member substitution transaction with another nonprofit that comes in and runs it. They need to do a deal. They're holding on to a thread of hope, or they haven't done a complete process to go out and find a buyer. And so they're doing a management agreement. And very often what happens is they're doing the management deal, handing over control to a manager who is really a potential acquirer. And that's sort of like getting engaged. You better like the one you get engaged to, because a wedding usually follows. So when you sign that deal, you better like them, because you're going to probably end up with them. If you don't end up with them, you're going to be in worse shape when you try to separate. So we get a lot of those. So those come with they usually come with a comfort letter from our offices. We've reviewed it. It's probably covered by a letter we wrote 4 years ago about a management agreement. It looks a lot like that one. You're probably not triggering the act. Of course, if you trigger the act and you don't have a hearing, your transaction's void. So people love those comfort letters. But it usually comes with a warning from us too, though, that says, that may not be in the letter, but there will be a warning to someone that says, you know, you're giving them a lot of control. Your board really needs to be active in thinking about where they're going with this hospital. You can't just turn it over to the manager to figure out where you're going. The other component we have is Hospital Acquisition Act hearings, which in recent times either involve a cash deal to just buy the hospital, or they involve a member substitution transaction whereby you've got just a nonprofit coming in doing a member substitution, much like the Piedmont Athens regional deal that was done here. End of the day, that deal looks a lot like it did before, except that Piedmont is suddenly the sole member of Athens Regional. We conduct a review process, involves public notice, public hearing, involves us hiring an expert that does a review of the benefits of the transaction, all the elements of the transaction. If it's a cash deal for a purchase, we'll review whether the consideration is adequate. And we review for-profit and nonprofit acquisitions of nonprofits. That's about a 90-day process in its entirety. We do a 60-day review, a public hearing, and then we generate a written report of findings. If you ever want to read one because you can't sleep at night, there are tons of them on the Attorney General's website. They're not the most prominent things on the website because they're not the things that most to avoid that process. They don't want to go through the process because they've decided it's burdensome or, just it's going to kill them. They don't have enough time to do it. We work with people. We try to get the deal done. But the transactions that they do short of triggering the act, as a general rule, they lead them to a worse place, in my view. You get to a worse place 2 years later where you say, we let the hospital down the road come in and manage. As part of that, we had to get them to guarantee our debt. Well, it's going to be hard to separate from those folks if you decide you want to. And that, one more tie back into the political process. I've seen that happen where they do the management agreement with the hospital in the big town a few miles over, and they don't have the politics in order, but they desperately need them. 2 years later, the politics turn against them locally, and so it becomes a decision of, okay, is the county going to guarantee the debt? Because the hospital down the road is guaranteeing the debt. Nobody wants to loan money to the hospital by itself. So there's a lot of moving parts, and you got to have a lot of coordination among your sort of your house, and you got to have your house in order. So all that's, I said a lot of stuff.
And so now, Rob, if we're talking about moving into the depths of bankruptcy now, which again is not always the worst thing, and that's part of what I want you to speak to, is the advantages and disadvantages of, if Chapter 11 bankruptcy is available to you. A local issue here is that a hospital authority in Georgia that's not been restructured into a nonprofit corporation, just the governmental entity, the corporate body politic is what they call it, is not eligible. A bankruptcy court has found that they're not eligible to file bankruptcy, so they could be even worse off than if they had been eligible. So speak to, as the creditor, as the debtor, as the successor, various considerations in whether Chapter 11 is the right decision for me. Should I undertake an expensive process to try to become eligible for it? And whatever else you might want to say.
Sure. Thanks. And I would echo a lot of the comments we've heard here with Scott's comments about board involvement and trying to bring the board members in and make sure you have a good process is very important. One of the things you see sometimes, unfortunately, when the ones that end up making it into bankruptcy and having a sale transaction or some other kind of restructuring transaction, Not surprisingly, there often isn't enough money to pay off all the debts of the old hospitals. So they're going to start looking around for ways to get those debts paid off. And one of the top things they'll look at is claims against the directors and officers of the old hospital. So not to raise the specter of litigation, but that's always kind of in the backdrop whenever you have an insolvent or a distressed company of any sort, and the same holds true with hospitals. And so a big part of the protection there, of course, one thing is make sure you have D&O insurance in place and you have adequate D&O insurance. If you're going to serve on a board, a nonprofit board, any type of board, I would say always check and make sure and find out what kind of coverage the organization has. My wife's a nurse in Atlanta, and she came and told me she got asked to be on this nonprofit board for an adoption agency. And I said, well, do they have D&O coverage? She said, I don't know. I don't need to worry about that, do I? And I said, yeah, you need to worry about that. And so she checked on that, and they did. So she's on that board now. But a big part of what protects you as board members is the process. If you can show you went through a process and that you were paying attention to what was going on at the hospital, if it's having problems, you took steps to address them. You've got the advice of appropriate professionals that you brought in, like Scott or Kurt, and you don't have to be perfect in your judgment. You just have to have gone through an appropriate process and used business judgment. You'll get protected by the business judgment rule later down the road. But also make sure you document your board meetings, resolutions, and things like that. I've seen in a lot, particularly with smaller enterprises, a lot of times they'll have the meetings, but they won't actually follow up and document it and have a good minute book and that they can show later if something comes up that, yes, we did consider this. We knew there were issues there. We took steps that we thought were going to help as best we could under the circumstances. But if you documented that, that'll help you down the road. But anyway, getting back to a couple of the issues about Chapter 11, usually by the time they come to see us, unfortunately, it's often too late, too little too late, or it's right at the last possible minute. And we certainly understand that. Nobody wants to file bankruptcy or Chapter 11 if they don't have to. It's an expensive proposition. There's an unknown factor to it. You're in a fishbowl in Chapter 11. Anything you want to do that's not in the ordinary course of business, you have to get court approval. You got to file papers, make things public records. And you've got other parties in the process who can raise objections, creditors, and it's distracting to management to have to do that. So I certainly understand that. But there are some important benefits potentially of Chapter 11 if you're heading that way. I think it's typically wise to have at least explored that and retained appropriate counsel from financial advisors and attorneys and accountants who specialize in that area to at least take a look at the situation and give you advice as to what you could do outside of a Chapter 11 context and what you could do and how Chapter 11 might be able to help you. Typically, the hospitals that we've represented and most of the other healthcare entities come in, a lot of times it's driven by the buyers. Okay, they're in a distressed situation. The balance sheet looks horrible. Liabilities are out of whack. They probably got, if they're a PIP facility, they've got some issues with Medicare because they've had a declining census, and they've been getting overpayments for a couple of years. So they've got some repayment plans in place where Medicare is recouping significant amounts, so that's constraining their revenues even more going forward, and it's kind of spirals downward from there. And the buyer comes in and takes a look at it, and they say, well, we're not willing to just come in and take over this entity and assume the liabilities. We might be willing to purchase the assets, at least some of the assets, and take some of the contracts if we can negotiate deals with the contract parties that might be owed a substantial amount of past due payments. But we want to make sure that we're not going to get sued later by these vendors that, frankly, are probably not going to get paid down the road. And so that's typically when they show up on our doorstep. A lot of times the management has perhaps put their head in the sand a little bit and not really addressed the possibility that they might have to go into Chapter 11. But the buyer says, we're not going to do this deal unless you take it through a Chapter 11, because one of the benefits of the bankruptcy process is the sale has to be noticed up to all the creditors and other parties in interest. You have to meet certain standards to show it's in the best interest of the creditors and everybody. And then you have a hearing, and if anybody wants to object, they can come forward and object. The judge makes a ruling. You have a federal bankruptcy judge who enters an order approving the sale. And typically these orders are quite lengthy, and they provide lots of protection for the purchaser, which helps make sure that they don't end up having to stand good for liabilities that they didn't intend to assume. And so that's typically how it gets to the Chapter 11 arena. And, usually in a Chapter 11, there are lots of transactional expenses. One of the downside of it is you've got to hire lawyers and accountants and financial advisors and others and steer you through the process. And that can be a significant expense for an entity that's already struggling. However, bankruptcy, once you file, does stop. There's an automatic stay that goes into place and keeps creditors from trying to collect pre-petition debt. So you get some benefit and relief from paying some of these past due debts until you get to the transaction and maybe get to a plan that offsets some of the additional transactional expense. And so that's something that the professionals can help advise people about. But as Mason pointed out, in Georgia, under the federal bankruptcy code, in order for a governmental entity to file bankruptcy under Chapter 9, which is like what Detroit took advantage of in Jefferson County, Alabama, the state has to allow them to do so. The state specifically its laws have to allow the governmental entity, the municipality, the subdivision to file Chapter 9. And Georgia statutorily prohibits its municipalities from filing under the federal bankruptcy laws. And so with these hospital authorities, there was a question as to whether they actually qualified as municipalities that could take advantage of Chapter 9 if the state let them. Because if that were the case and the state doesn't let them, then they can't file bankruptcy at all. If, on the other hand, they were not considered municipalities or governmental subdivisions, they could actually file like any other private company perhaps under Chapter 11. There was a case by Judge Dallas in the Southern District of Georgia a few years back that really kind of answered that question. I think it was a pretty well-decided case based on the language of the statute, which basically says that hospital authorities are considered, they really are governmental subdivisions, they are municipalities. So they would have to have permission from the state in order to file, and they don't have that permission now. So if you're in a situation in a community where your hospital is owned by the authority and it hasn't been restructured to set up the operations into a nonprofit corporation, which can file under Chapter 11, then you really don't have the ability to file for relief under the bankruptcy code. And so that actually could be a real detriment if you're trying to find a partner to do a transaction with, because they're going to be a little more hesitant to do a transaction if they can't get that protection that I just talked about. On the other hand, there might possibly be some other, I wouldn't, even in that situation, I'd say go and get some advice, because it's possible, we haven't done this before, but it seems to me it might be possible to maybe through a state receivership proceeding or a federal receivership proceeding, get some relief and perhaps get some injunctive relief from the judge to protect the assets of the hospital, even in that situation. I don't know if that would work or not, but it's something that certainly might be explored. If you are in one of the restructured areas where you've got the hospital set up with the nonprofit, the typical 40-year lease, where all the operations are assigned to the nonprofit, you can file Chapter 11 and take advantage of the relief provided there. It's not an easy thing to go through Chapter 11. We've found out. I would say one bit of advice: if you're doing that, start talking to Wright's office as early as you can. Make sure you have a good pipeline and communication with DCH, because you're going to also have to get approval to assign any CLNs that you might have, because that's likely one of the most important assets that entity may have. And I would also say, just because a regulation or statute seems to indicate maybe you can't do it, don't be afraid to ask for a waiver or get them to help you. We found in our cases that, for example, in the Hutchison case, right after we filed in November of 2014, we were about to literally run out of money and not be able to make our payroll. And I didn't realize until after we filed, they came back and said, well, we're not having enough money to make payroll next week. We're going to have to shut down. I said, well, what are we going to do about it? I don't know. Well, they were expecting a dish payment that was coming in, a pretty sizable dish payment about a month later. And we were able to, basically in that situation, the only way we were able to survive was to actually go to DCH and to the really working through the local politicians and the governor's office. Luckily, it was an election year. I think that might have helped November. And they actually were able to accelerate a dish payment, a pretty sizable dish payment, and we made payroll and that allowed them to continue to move along. The same thing happened in the Southern case. DCH worked with us with respect to the CON assignments and did some things that I think if we hadn't asked for it, we might not have gotten. So, try to keep an open line of communication, and you really have to think outside the box in these situations. In my experience, particularly in a hospital scenario, it's really, I found it to be probably the most challenging situation to try to reorganize and restructure and guide them through Chapter 11, just because of these other statutory interplay with other regulatory sections, and you got Medicare issues, and you're dealing with sometimes, hopefully, your provider agreements, or you're in good standing under your provider agreements, and that's not an issue. But I think communication is key. Nobody wants to get there, but certainly the bankruptcy code and the bankruptcy laws might be available to help save a local hospital, particularly if you've got a transaction partner who's going to come in under a management agreement, perhaps, or purchase the assets. Or frankly, one of the purchasers we looked at in Hutchison was a telemedicine company. I think it was called People's Choice Hospitals, and I'd never heard of that before. And I was amazed. I went on their website, and they were essentially just going to continue to operate the ER and keep some of the beds open, so that once they kept the ER open for the community, and they could get people stabilized and had enough beds open to handle, let the patients get stable, and then perhaps transfer them off to other area hospitals. But some of these other services were going to be handled, through telemedicine, and I thought that was a very interesting idea. I was interested to hear some of the other sessions today and the trends that are going on in that area. I think that's something that certainly seems to me like might help fill the void for some of the issues that we're facing. So.
There's a lot of very expensive right exclusion. Do you have any questions from the audience?
I have a question for Rob. So you talked about the ability of capital for a hospital that don't have a fire. What about a hospital that finds itself without a hospital? Are there other avenues in Chapter 11?
Yes, that's a very good question. Yeah, it would be possible to do a reorganization. With the nonprofit, of course, you don't have any shareholders, but typically you have a creditors committee formed in these cases to represent the interests of the vendors. With a reorganization plan, of course, what you probably would do, you'd have to of course, get the operational expense down, and generate revenues post reorganization sufficient to fund a plan. So you'd have to come up with essentially the game plan. Either you're going to skinny down the hospital, perhaps eliminate some services if your CON allows you to do that, and you can do some things with that. I know in the Hudson case, they opened a service for a while, and you could only have certain services had to be operational, but you could shut them for up to a year. So they were playing a little bit of we'll close this service and reopen it, and we'll open just enough to keep the CON going. But with contracts, one thing the bankruptcy laws let you do, you can reject what we call executory contracts or leases, and a lot of times that gives you a valuable tool to go renegotiate. So you can use the potential to reject a contract with some of your big equipment providers, your lessors, and basically wrap that into your plan. And so you could use Chapter 11 to restructure under a reorganization plan. Typically, a lot of times there are management issues when you go into Chapter 11, and sometimes it's not really poor. Sometimes you do have some poor management issues, but sometimes it's just understaffed. The management is overwhelmed. They've cut into the bone and don't really have adequate support, particularly on the financial side. And so you can maybe bring in somebody under a third-party contract, a management contract, as part of your reorganization plan to come out. And if you're able to show that the plan's feasible after you do the restructuring and convince the court and get the vote of the creditors, you should be able to get reorganized. In order to get the vote of the unsecured creditors to get an accepting class, you have to have over 50% of the number of creditors that actually vote in that class and over 2/3 of the dollars. So you don't have to have unanimity, but you have to have enough of them basically to satisfy that requirement, and the court will be looking for that as well. So yes, it's a possibility, certainly.
I'll do one last question. What's, for this for anybody, what's one state or federal change, policy change that could help really distress providers? I mean, your soapbox could be anything, but I'm thinking, really in that moment of distress, that pivotal, what do I do now, sort of moment, what's something that you think is a real hardship for the hospital?
My job does not involve advocating for changing the law, but I will say this, that we administer the law as it is given to us. The Hospital Acquisition Act in Georgia was written because there was a belief or a concern that charitable assets of nonprofit community hospitals were being sold. Mostly the concern was sold to for-profit operators for a extremely discounted price. And so the charitable asset that the county had built up was being sold at a really discounted price without a proper process for finding a buyer. If there were a legislative change to address, if you're in a certain state of financial distress and you're doing a sale, I have had a lot of hospital hearings where they were darn lucky to have a buyer. It wasn't a matter of they were selling at a discount. It was just they were, the ongoing operation had really no value. Wanted to keep the community hospital open. Somebody was willing to buy it and try to keep it open, and it was the only deal in town. So there's a policy issue there in that what the act was originally written to address, and it involves putting a burden on the selling hospital to go through a lot of steps and process. And it's all about process, that if you're in a certain state of financial distress and the law were rewritten in a way to give you some flexibility to do a deal faster, cheaper, that might be a policy change that in Georgia would help some folks. I suspect, this is just me saying where I think things are, I suspect we're going to see more filings like Rob's talking about with a sale deal. I think if I'm a for-profit buyer in Georgia that's looking to buy a community hospital, I want it to file Chapter 11 because I want to clean it up as much as I can before I take it. I don't think we're going to see a lot of bankruptcy reorganizations of them, but I think we're going to see a lot of filings with sale motions coming in fairly quickly. So.
Well, I think we're pretty much out of time. So thank you four and all of you for sticking around this late on a Friday. Really appreciate it. This is our second year doing this event. Hope to be back next year. Hope you'll be back next year. It's a it's a issue that's not going to resolve itself in 6 months. Let's face it. This is an every year thing, and we want to increase awareness. So thank you again for being here, and let's continue to help get the word out. Thanks.